May I first of all remind members that social distancing measures are in place in the Chamber and right across the Holyrood campus. Can I ask that members take care to observe these measures over the course of the afternoon's business, particularly when entering and exiting the Chamber? And the first item of business is a preliminary stage debate on motion 22407 in the name of Christine Graham on the Solicitors and the Supreme Courts of Scotland Amendment Bill. May I ask those who wish to speak in the debate to press the request to speak buttons, and I call on Christine Graham to speak to and move the motion for up to 8 minutes, please.
Thank you very much, Presiding Officer. I'm pleased to open the preliminary stage debate on the Solicitors in the Supreme Courts of Scotland Amendment Bill. I thank my colleagues in the Private Bill Committee, Bill Bowman, the Deputy Convener, Daniel Johnson and John Mason for their work in getting the bill to this stage. The bill was introduced on 26 September 2019 and is being promoted by the Society of Solicitors in the Supreme Courts of Scotland, known as the SSC Society. This is the fifth private bill to be introduced in the current session. The previous four have all received royal assent. Now, the private bill process is something quite different. The first stage of the private bill process differs from that of public bills, which we are more familiar with, as it begins with a 60-day objection period. During these 60 days, any person or organisation which believes that their private interests would be adversely affected by the bill can lodge an objection. The objection period for this bill concluded on 25 November 2019 and no objections were lodged. At preliminary stage, the role of the committee is twofold. Firstly, to consider the general principles of the bill, and secondly, to consider whether it should proceed as a private bill. In considering whether the bill should proceed as a private bill, the committee assessed whether it conforms to the definition of a private bill and whether the accompanying documents are adequate to allow proper scrutiny of the bill. If the Parliament passes the bill at preliminary stage, the bill moves to consideration stage when amendments are considered. Thereafter, the bill proceeds to final stage for consideration of any further amendments and a decision on whether the bill should be passed. In order to understand the current position in which the Society finds itself, it's helpful to understand its history and the history of the legal profession in Scotland. The Society of Solicitors in the Supreme Courts of Scotland has been in existence for over 200 years, longer than me even. The Society was formed in 1784 with a contract and articles of association and regulation, and a royal charter was granted in 1797, making the Society a body corporate. In 1817, a widows' fund was established to pay annuities to the surviving widows and orphans of the Society's members. The Solicitors in the Supreme Courts of Scotland Act 1871 confirmed and amended the Charter and reincorporated the Society. However, one omission in the Act was any powers for the Society to wind itself up, either because the then members did not foresee a day when the Society may not exist, or because they deliberately did not include any powers that would allow the Society to close down. Now, the Law Society of Scotland was established in 1949 and took over the business of regulating the legal profession. In 1979, get my centuries muddled up, in 1979, elements of the 1871 Act were amended to reflect the changes that occurred over the previous century. The benefits of membership today include access to the Society's building at Parliament House in Edinburgh, use of a legal library and members' lounge, and membership of the Widows' Fund. The Society currently has around 220 members spread throughout Scotland and 46 beneficiaries of the Widows' Fund, each of whom receives an annuity of £3,000. The Society is run by 5 office bearers and a council of 6 members. Over years, demographic changes within the membership have meant that the Society now finds itself with a predominantly older retired membership, with fewer younger members joining. This apparently is not unusual for these types of societies nowadays. There is therefore a concern that a dwindling number of members may find themselves one day in the position where the Society, or Widows' Fund, or both, needs to be wound up but with no powers so to do. This bill therefore seeks to update and modernise the Society's statutory constitution, that is, the 1871 Act, by updating the Act for modern conditions and by giving the Society additional powers which it may need in the future. The purposes of the bill therefore include renaming the Widows Fund as the Dependents Fund and providing the Society with powers to either close the fund to new members or to close it completely. Secondly, giving the Society powers to wind itself up in the future. Thirdly, creating new types of membership and making new provision to allow members of the Society to resign. And fourthly, abolishing the offices of librarian and fiscal. Part of the committee's role is to assess whether the bill will actually achieve these objectives. In order to aid its scrutiny on 17 December 2019, the committee held an evidence session with the Society's office bearers and its drafting advisor. As a committee, we asked the promoter what alternative approaches had been considered and what the implications would be if the bill were not passed. The promoter emphasised that they are not expecting to wind up the fund or the Society anytime soon. However, they wish to have the mechanisms in place in case they are needed in the future, so that winding up can be done in an orderly fashion without requiring an urgent action before the Court of Session. We also asked how the winding up of assets would work and questioned whether the procedures for closing the newly named Dependents Fund and winding up the Society were robust enough. Our report sets out our considerations and recommendations, and my committee colleagues will provide some more detail on these later in the debate. The committee supports the general principles of the bill and agrees that the bill should proceed as a private bill. We believe the bill will provide the Society with the powers it may need for the future and, in addition, updates its statutory constitution for modern conditions. Therefore, I'm pleased to move the motion in my name, Presiding Officer.
We now move to the open debate and speeches of around 4 minutes, please. And we have John Mason to be followed by Daniel Johnson.
Thank you very much, Presiding Officer. And I too would want to thank the convener, other colleagues, clerks, for their help and work on the bill up to this stage. I would also thank the promoter for showing us around the Society's headquarters at Parliament Square, just up the road. Bill Bowman, the clerks and I saw the building where the Society is located, in close proximity to the Court of Session, the Faculty of Advocates, the WS Society and the High Court. It was interesting to hear from Robert Shields, the Society's Secretary, and that he noted that many of the early members of the Society had entered the legal profession through apprenticeships rather than with law degrees. The visit was therefore helpful for providing background and context to the bill. For my contribution, I intend to concentrate on the mechanisms required in winding up the Society and certain aspects of the Society's meetings. One of the main aims of the bill, as the convener mentioned, is to address the lack of powers in the 1871 Act to wind up the Society. It is understandable that office bearers do not wish to find themselves, as one office bearer put it, quote, aged 85 and the only person left at the table, unquote, only able to, quote, resign from office, walk away and leave an organisation that still exists with nobody to manage it. The bill therefore inserts a new section 52B into the 1871 Act. This new section sets out the general process for decisions on winding up the Society. The process starts with the Council agreeing a proposal to wind up the Society, followed by either a general meeting of the members or bylaws being made to decide the procedures to be followed at a special general meeting. The Society's members must be given at least 30 days' notice of the special general meeting, at which they will then consider the proposal to wind up the Society using the previously agreed procedure. If the members vote to wind up the Society, the Council will then implement this decision either in accordance with arrangements made by the Society or in such manner as the Council considers expedient. During the evidence session, the committee questioned whether the procedure to dispose of the Society's assets was detailed and robust enough to encompass any worst-case scenarios during the winding-up process. We commented that division of assets, particularly substantial assets such as the Society's building, could create tensions. I therefore welcome the promoters' confirmation in a letter to the committee following the evidence session that they are considering proposing an amendment to the bill to ensure that the Society's members are consulted about how property is to be distributed. The committee also asked the promoter about the process of voting at the Society's meetings, particularly upon hearing that only around 10 of the current 220 members generally attend the statutory general meetings. We noted our concerns about the lack of requirement in the bill for a quorum and that a voting threshold was not mandatory for meetings where winding up decisions are to be taken. I therefore also welcome the promoter's confirmation that they propose amendments to address these issues. Presiding Officer, I hope I have provided members with sufficient useful detail on our considerations regarding the bill's provisions that give the Society new powers to wind itself up. And we share the promoter's hope that the Society will not find itself in this position for some years to come, if at all. I have personally found this a very interesting process to be involved in, but it has underlined for me that it can be cumbersome to amend primary legislation, so perhaps a lesson for us nowadays is that we do not want to put too much detail into primary legislation if we can avoid it. So in conclusion, I fully agree with the committee's conclusion that it is content with the general principles of the bill and that the bill should proceed as a private bill. Thank you.
The last speaker in the open debate is Daniel Johnson.
Thank you, Deputy Presiding Officer. And can I begin by thanking my colleagues. It's been a real pleasure to work on a private bill, and indeed interesting, given that it is different to our usual work. Can I also thank the convener, Christian Graham, for moving the motion and indeed explaining the history of the Society and the process for a private bill. But above all else, I think it's important to thank the clerks who have really assisted us greatly, not just with the detail of the bill, but also the process of a private bill, given the unusual nature that is for most of us. So, as the convener mentioned, the bill is necessary due to the changing demographics within the Society, where an ageing membership means that the office bearers may one day find themselves in the unhappy position of having to wind the Society up. The committee therefore agrees with the promoter that it is necessary to ensure the relevant powers are in place should it become necessary to one day close either the Widows' Fund, to be renamed the Dependents' Fund, to close the Society, or both. The provisions in the bill that deal with the closure of the Dependents' Fund will insert new, detailed procedures into the Solicitors in the Supreme Courts of Scotland Act 1871. This will include an actuarial investigation, a meeting of the members to consider a resolution to close the fund, and the offer of such lump sum or other payment as seems reasonable for the annuitants and the potential future annuitants. Any residual money would then transfer to the Society. Whilst the committee generally agreed with these procedures, we asked why the decision had been made to transfer any surplus back to the Society. Donald Skinner-Reid, the Treasurer and Collector, explained to the committee that the Society would seem the natural home for any surplus in order to assist the Society's continued existence. The promoter also emphasised, both in the evidence session and in a follow-up letter to the committee, that the surplus in the fund may be smaller than might be imagined once the lump sums had been split between the annuitants and potential annuitants. In its report, the committee recommended that the promoter consider, as part of the winding up procedures, a provision in the bill that the beneficiaries and any prospective beneficiaries should be notified of a proposal to close the fund. The promoter has accepted this recommendation, and a draft amendment has already been shared with the committee. The committee also examined the procedures involved in winding up the Society. The committee is keen to stress that its aim is to ensure that the bill and the new powers and procedures it introduces to the Society's constitution are as robust as possible without restricting the right of the Society's members to make decisions about its future. We are in agreement with the promoter that if the Society does in the future need to wind itself up, we do not want it to have to come back to Parliament needing to amend the legislation again. We therefore highlighted areas where we thought that the winding up procedures could be strengthened. In particular, we questioned provisions for quorums, voting thresholds for key decisions. John Mason has covered this in some detail, but I wanted to note this point as well, and indeed the promoters' agreement with those recommendations. Deputy Presiding Officer, it has been interesting to experience the private bill process so far and to play a slightly different role to the usual one of a committee member. As the convener mentioned in her opening speech, the committee has concluded that it is content with the general principles of the bill and that it should proceed as a private bill. Thank you very much.
I now ask Bill Bowman to close the debate for up to 8 minutes, please.
Thank you, Deputy Presiding Officer. In closing, on behalf of the committee, I too thank my colleagues for their work on the bill so far, and I also would like to thank the Society's Secretary, Robert Shields, for showing us around the Society's building at Parliament Square. Mr Shields recounted how the courts originally rose up around the old Parliament of Scotland, which led to societies being formed by the lawyers that worked in and around these courts. Standing in the magnificent Parliament Hall and seeing the Faculty of Advocates, the WS Society and SSC Society, all located in close proximity to the Court of Session and High Court, gave a tangible sense of the history of these societies and the role that they have played in our legal system over hundreds of years. I would also like to note at the outset that, as the promoter has emphasised, despite challenging demographic changes, there is no current wish at the present time among the Society's members to close the Society down. One of the objectives of the bill is therefore to enable the Society to attract new members. By amending the Solicitors and the Supreme Courts of Scotland Act 1871 to create different forms of membership, for example, corporate membership, trainee membership and associate membership. This will hopefully encourage younger members of the legal profession to join the Society and to make use of the library and facilities at the Society's building in Parliament Square. One concern that the committee raised in the evidence session was the possibility of a sudden influx of corporate or associate members who might then disagree with a decision taken by the small group of remaining full Society members. The promoter responded by explaining that it would be clear from the outset, and indeed in the bill, that these new types of members would not have voting rights. The bill also contains a provision which will give members the ability to resign their membership, unconnected from any disciplinary matters or retirement. At present, if a member fails to pay their membership fees for 2 years, their membership automatically ceases. However, we heard from the promoter that this is an unwieldy process and that allowing members to resign their membership would be useful. One of the other objectives of the bill is to update some aspects of the Act's terminology. As we've heard, Widows Fund is being changed to Dependents Fund, and reference to lawful children is being removed. The bill will also allow the trustees to pay annuity claims based on cohabitation, depending on the facts and circumstances between the deceased member and the claimant. Donald Skinner-Reid, the Society's treasurer and collector, was frank about the fact that the mechanics of how this might happen have not yet fully been worked out, and that in any case the law regarding cohabitants' rights is continuing to evolve. The promoter is also removing the offices of librarian and fiscal, as the role of fiscal was a historic office for handling matters of discipline prior to the formation of the Law Society of Scotland and the Scottish Legal Complaints Commission, who now handle such matters. The office of librarian is being removed, as although the Society will still have a librarian, that person is no longer required to be a qualified solicitor. The last area I would like to cover today is the committee's role in considering whether the bill should proceed as a private bill. This aspect of the private bill process is one that most committee members had not encountered before, as it isn't part of the process for the public bills that we normally scrutinise. The committee is required to satisfy itself on 2 points: that the bill conforms to the definition of a private bill as set out in standing orders, and that the accompanying documents conform to the Parliament Standing Orders Rule 9A 2.3 and are adequate to allow proper scrutiny of the bill. On the first point, the committee is satisfied that the bill conforms to the definition of a private bill. On the second point, the committee is satisfied that the accompanying documents fulfil the requirements and allow for proper scrutiny, although we did note that the promoter's memorandum could have provided more detail about whether any negative responses or comments from members were received. The committee is content with the promoter's conclusion in the promoter's memorandum and in the evidence session that promoting a private bill is the most appropriate and best available method of achieving the promoter's aims. However, the committee did have one recommendation regarding the promoter's statement. We noted in the preliminary stage report that the promoter had stated their intention to inform all the tenants of the Society's building about the bill. In the evidence session, the promoter confirmed that the tenants in the lower part of the building had not been informed, in part because the bill would not alter that tenant's position. The committee therefore recommended that the promoter ensures that all tenants are notified about the bill and the proposed changes to the Society's constitution. A follow-up letter from the Society's Secretary has stated that such letters have now been sent. So in conclusion, Deputy Presiding Officer, I welcome the promoter's acceptance of all the recommendations that the committee has made in its report and that they will propose amendments to be lodged at consideration stage to address these recommendations. I too can confirm that the committee recommends that the Parliament agrees to the general principle of the Solicitors in the Supreme Courts of Scotland Amendment Bill and that the bill should proceed as a private bill. Thank you.
Thank you. That concludes the debate on Solicitors in the Supreme Courts of Scotland Amendment Bill, and it is now time to move on to the next item of business. I note that front benches generally are empty around the chamber. Can I remind members that business carries on from one item to another? There are no set timings.